welcome to all those viewing live and all those who may view on a recorded version of this. Today is going to be the seventh and final in a series of webinars that have been provided on receivership and receivership administration. In connection with past seminars, we began with how to initiate a receivership, how to finance and administer assets in a receivership, how to conduct free and clear sales, and how to conclude a receivership. And then we started to move into some more unusual and complex types of receivership matters, including free and clear sales in more detail and the different state law variations on those items. How to deal with a cannabis company in receivership, which seems to be a very common type of receivership. And today we're going to be talking about other types of unusual assets and tips for administration. And the goal here is to demonstrate for viewers that not only is a receivership a valuable process and an available tool when the appropriate professionals are engaged, but also something that is that can be shaped to fit many situations. And so today we're going to be talking about some of the more unusual or complicated or involved types of cases, just as a demonstration of how receivership can lend itself to most any circumstance that otherwise justifies it. Our sponsor today, our producer is Financial Poise, and our co-producer is National Law Review. And we want to also give thanks to our sponsor, Max Asset, which is a company that provides online single asset sale facilities that are valuable in the context of receivership and receivership administrations. Before I get into the detail on what we'll be covering today, I'd like to talk to you about our all-star panel. We're very fortunate today to have three very experienced receivers and turnaround professionals here to talk about their more kind of challenging assignments that they've seen over time. They're Jeremiah Foster, Baker Smith, and Brent King. Jerry Foster is the president of Resolute and a nationally recognized leader in restructuring. He's handled over $4 billion in distressed transactions and more than 100 times has been appointed by courts across the country to administer some of the most difficult and complex receivership cases that one can imagine. Baker Smith is the managing director for BDO Restructuring. He himself has over 30 years of experience, has led over 300 crisis management teams. He's handled over 25 million to several $billion in revenue companies. He's been appointed not only as a receiver, but a restructuring officer, CRO, a chief operating officer, a trustee, and a CEO. And I think he has also done some work in helping with bank groups dealing with the College Football Hall of Fame. And Brent King is with Glass-Ratner, and Brent has handled a great many receiverships, and I've worked with him personally any number of times. He has over 35 years of experience in dealing with receiverships and turnarounds, has specific expertise in agriculture turnarounds, although he's not limited to that. He's been appointed as a CEO, a CRO, a receiver, a Chapter 11 trustee, and an interim CEO. And I'd encourage you to take a look at the conclusion of the seminar, the bios for each of them. And I know any one of them to whom you might have a question if you can't answer it or get an answer in the chat, would be very happy to hear from you offline as well. And their contact information is included in the materials. So as you might have gathered from the outset of this presentation and the introduction, not all assets that go into receivership are simple buildings or office buildings, hotels. They're not always just cookie cutter types of cases. And in prior seminars, we've talked about how different types of assets are administered differently, how different states have different rules, protocols, and statutes for administering a receivership, and different things you can achieve in some states, while in other states, not as much. And as we've done this seminar over the past couple of years, we've seen states continue to improve their receivership statutes. At this point, approximately 17 states have updated their receivership statutes to afford practitioners a more comprehensive and to afford courts a more comprehensive and clear means of administering assets. That's a great benefit not only to the receivership business itself, but to the practitioners who otherwise find themselves often having to educate judges on the fly. Sometimes those judges may not have had a receivership case before. And so these statutory provisions have greatly enhanced the utility of receivership. And ultimately, receivership is a powerful and complex tool, but it is also a malleable tool that can be crafted to fit any number of circumstances. And consequently, it's important that you have the practitioners in place who have done it before, who know how to guide practitioners and courts through it, and who can get you to a successful conclusion of maintaining assets and hopefully maintaining the value of those assets and escaping the receivership with the best possible result. Today, we're going to talk about the unique circumstances that apply in several different situations in a receivership. And they are case studies to demonstrate two things. One, that receivership is valuable and useful in non-real estate situations, and to assist and is available to assist in maintaining sometimes difficult to maintain assets. It is also valuable in turning around those assets and in maximizing recoveries where the alternatives are simply a liquidation. And so in order to get to that, what I'd like to do is set out the first case study, and I'm going to turn to Mr. King on that. And that is a situation involving livestock. You've got live animals at different stages of production, and you've got someone who is in financial distress, perhaps can't afford to feed them, can't afford to deal with animal waste. Maybe you have power problems, and there's a great deal of risk associated with administering these assets. And so I'd like Brent to tell us some background on a recent case in which he has been a receiver, and in this instance, it's a hog farm. And if you could kind of give us the background of that and what you walked into when you first took office.
Of course, thank you, Eric. Well, hog farming is actually an odd sort of receivership for most receivers, but I was fortunate enough to have grown up on a hog farm and raised hogs most of my adult life. And so for me, it's a normal experience. But the unusual aspects of hog farm have to do with the overall architecture of hog farming and the modern industry of pork production, in which from the moment a sow is bred until the moment her offspring are sent to market, there is a continuous flow of pork through the production system at the farms and all the way then through the harvest systems, the shackle spaces and the harvest systems at the packing plants. So one of the most difficult things that will have to be assessed first in a hog farm receivership is, do you continue to breed sows? And to make that determination, you have to look far into the future. The gestation period, 3 months, 3 weeks, 3 days for a sow. Weaning period, the nursing period, through the weaning period, through the growth and market period. So one of the very first things that we have to always come to terms with is whether or not we're shutting the farm down or not. Because if you're shutting it down, it may not be marketable as an ongoing operation.
Let me back into this just a little bit. I think a lot of people, practitioners, lawyers, accountants, have and associate receivership with hotels, office buildings, stationary assets whose value is not really fluctuating that much. And even in those instances, it can be challenging because you've got to maintain the rent rolls. You've got to make sure there's insurance. You've got to do various things to keep the building operating smoothly. Now you're talking about a hog farm where the value of your assets is a living creature whose value is driven entirely by what weight and what health is it experiencing on a week by week basis. How, as a receiver, do you adapt that receivership process to address this potentially diminishing asset pool, which is so unlike a commercial building or a hotel?
Well, first of all, you have to peer into the future to determine the ultimate price of the livestock that's on the farm when it does reach market. So there is a consideration there. I think a very healthy approach to that question, Eric, would be to assess the potential recovery from continued operation, the net of costs and collections, and then go to the lender and set this firmly on their desk and say, you either fund this and here's what it's going to cost, or you have to tell us we're not going to, and we are left with no alternative but to stop feeding these pigs, which means certain things. In 2020, for example, I was the receiver of a large hog operation in central Missouri, and it happened to occur at the same moment that the US pork packing plants closed approximately 23% of the total aggregate kill space and the hogs kept coming. So we were literally faced in the entire pork industry with the need to euthanize living animals and find a way to dispose of the carcasses. It was a very unfortunate situation, and all of these things have to be addressed. When the cost to feed the pigs could far exceed the value that they will achieve in the market, or as an ongoing, as a carcass, or their value to another producer who may come in and step in and buy the farm and continue the operations.
How did the court, I assume the court understood that this is unlike the prototypical receivership, which is a hotel or an office building. You have an asset pool that is not generating revenue. It is purely a cost at the moment. It may generate revenue down the road, but you have to sink additional costs in. There is a requirement that new funding come in. Otherwise, the assets will die. And if the new funding doesn't come in, then how is it that a receiver can take this system that is so frequently associated with stationary buildings whose value doesn't disappear and apply it to a situation where, whether you're going to be able to maintain the hogs or whether you're going to have to euthanize them, both of them have expenses associated with them, and both of them have very strict regulatory requirements. How is that navigated using a receivership case?
Well, first thing that comes to mind, Eric, is it's probably a very good idea to do an ag receivership in a small town courthouse, where many of the receiverships I've done, the judge was actually a farmer, which is very helpful. I've done other hog farm receiverships in St. Louis. And Eric, I think your firm helped me on one of those. And I found a very distinct difference between the understanding of the urgency in St. Louis as opposed to Linneus, Missouri, a little tiny town up the road from Kansas City, where the judge happened to have a good friend who was also a hog farmer, and he raised some corn on the side. So the first thing we have to do is get the court on our side, and I think the next thing you have to do is get the bank on our side. But as far as the Missouri Commercial Receivership Act, it is a very broad and powerful piece of legislation. It gives receivers extremely broad powers. In essence, it almost facilitates everything that I could possibly need to do in managing this hog farm, but I have to organize it, create a plan for the management, and create a funding mechanism, and then get the judge on board to tell me to do it.
Now, in doing all this, and we've talked in prior seminars about the importance of the appointment order in a receivership, are there special provisions that you would encourage people to consider inserting into a receivership order that tailor the receiver's power and authority to the circumstance, number one, and number two, with respect to financing and your discussions with the lender, presumably, who initiates the case, do you get your budgeting discussion completed before you agree to accept the appointment? In other words, is that something you put into your receivership order? How is that handled? Because I imagine you wouldn't want to get appointed receiver and find out no one wants to give you any money, but now you're in charge of 4,000 hogs.
Okay. Yeah, it's a very good question. I always put in my receivership order that the bank will fund at least the operational costs of the receivership estate itself, meaning my professional fee, the lawyer's fees, the receiver's fees, and some basic budget. We all know too well what happens when the banks don't fund the receivership. We've been stuck in catastrophes that were created by lack of funding. But we're talking about real animal welfare issues here. And so it might be almost impossible to get the bank to fully commit to fund the farm in the time before I'm even receiver and on the farm to know what's actually going wrong. Because one of the things that can happen in a hog farm, for example, and this happened in the receivership I mentioned in central Missouri, the farmer was running the manure down the creek because he didn't have the money to properly apply it on the land. And so when I began to realize these were things that were impossible to predict until they were known, I've always tried to convince the bankers that you may not have an obligation to continue a long-term operation on this farm, but you simply cannot accept the negative press that will result if you fail to feed and care for your collateral until it's responsibly disposed of.
So in this, take the Central Missouri hog farm case, did you have a successful outcome?
Yes, we were able to liquidate all of the swine, return all of the buildings to the owners or their secured creditors. And we were able to do that in the midst of the COVID crisis without any um, euthanizing of swine.
And do you feel that other than a receivership, what would have been the alternative process? Would it be a Chapter 11? What would, or just a straight, I don't know, can you do a foreclosure when you're talking about live animals? What's the alternative process there?
Any alternative would have kept the producer in charge, and that would have led to a very negative outcome. I think the receivership was a very good, it was an extremely effective tool, in part because I happen to have so much experience in receiverships and I grew up on a hog farm. So none of this was foreign. But I think also because we had a very understanding and careful judge, and we had a bank that realized that they had an obligation to continue to feed the livestock, and they did.
Well, I want to shift this over. And I'm going to ask Jerry a question because Jerry has perhaps the most unusual receivership case I've ever heard of. And it is, I mean, it's like a series of knots, and I don't know how they get unwound. Um, Jerry, you were or are maybe still the receiver of a fertility clinic. So we're not talking a hog farm, but we are talking about quote unquote assets that could lose their value because a fertility clinic consists of storage of embryos frozen and apparently a designation as to who those embryos belong to. But you walk in and the company has no money, and the only real equipment you've got is freezers. And I'm not sure there's a huge market for frozen embryos, but why don't you tell us a little bit about what you walked into in the fertility clinic case and how you were able to use the receivership process to administer that very thorny matter?
Yeah. Eric, thank you so much. And I'm grateful to be a part of this group. I appreciate you reaching out to ask me to participate. And I too have gained the benefit of your partner's participation with me through this case. So perhaps you have somewhat of a second, kind of shotgun seat through our experience here. But unlike the experience that Brett spoke to, we have a really unique case, not in a variety of ways. So let me start. I think the most important thing that's a distinguishing feature here is that there was really no secured creditor. We were appointed by the Tennessee Attorney General's office as a consumer protection action. And it was for the benefit of the patients whose collateral was essentially kind of in limbo related to the doctor's unilateral communication that he laid off all the staff, he shut down the office, was out of money, and was threatening to didn't know how he was going to make his power bill, which directly affects the freezers that had 1,500 embryos in them, which further complicated by the idea that Tennessee is a fetal person state. After the Roe v. Wade overturn, basically all of the decisions related to fertility is now based in a state's hands. And a number of states have weighed in one way or the other. Tennessee, in particular, has come down and believed that the definition of a person is actually at the creation of an embryo. So, unlike most situations where you can't likely apply the notion of a receivership over a human being, I, in fact, I guess, had the dubious distinction of having a receivership over 1,500 human beings based on the definition in the state of Tennessee. Uh, and so, again, no secured creditor. I simply had the faith and confidence of the Attorney General of the state of Tennessee as the motioning party for the appointment of the receiver. Another thing that's interesting about our case is that we have a conventional receivership order, but it's nested inside a temporary restraining order to prohibit the doctor from having any further contact and almost freezing him out from complicating or ultimately impeding our ability. Not to say that wouldn't exist in a normal receivership context, but they wanted to absolutely gain the attention of the judge for this egregious behavior and recognize that we needed our ability to do the job without a whole lot of contention.
Right. So, but here's the fascinating thing. You walk into this case, you're appointed receiver, good for you. The attorney general thinks you're the best. And you walk in, let's say you get the money to pay the power bill so the embryos don't thaw. Congratulations. Now you have 1,500 embryos. What do you do with them?
Yeah, so let's go back because I think your nuance is really important. We started with very, very little money, almost zero. And our approach to this was really one of partnership. We struck and tried to appeal, and thankfully everybody understood what was at stake here. I mean, these are really high stakes situations. I mean, the notion of holding 1,500 lives in your hands is not lost on me, nor was it lost on the staff, and clearly not lost on any of the stakeholders. So I'm grateful that for the large degree, we had a wonderful group of partners, to include the landlord, who we were on a full service lease. So technically, I wasn't responsible for the electric bill. I just asked for some patience and leeway with the landlord. And we happened to be housed inside of a hospital facility, so they would never be in jeopardy of turning off the electricity. And therefore, my freezers would always be in good standing, provided that we could keep them in the facility and the landlord didn't try to evict us. Second to that is the idea that the Attorney General's office was an incredible partner here and has largely funded the receivership through the entire process. And so, going back to your initial question, like, what do you do? We basically walked into a doctor's office. So, and it had a little bit of a minor surgery center at the back. But I mean, there was nothing remarkable or in particularly anything valuable in the space. And obviously, the entire need for the receiver revolved around this genetic material, which obviously carries a heavy weight. There's impossible to put a value on it. I mean, again, there's a lot of high wire acts here in terms of trying to value the life of a human being. I wasn't going to get into that. Trying to recognize that when you're talking about embryos, recognizing they're human beings, the ability to transition them or transfer them over state lines turns into kidnapping. Didn't want to do that either. There is actually a case in Alabama that also believes that life is created at the embryo, where an individual working in a fertility clinic dropped a test tube and is currently in jail for actually killing a human being. Didn't want to wade into that either. So those are some really heavy consequences associated with the work that we did here. Thankfully, we're on the backside of all of that. What we were eager to do from the beginning, and where we usually try to create a strategy in our desire to find solutions, is we come up with what is our North Star. And we use that North Star in terms of all of our decision making. In this particular case, the North Star is what is in the best interest of these patients. And with that in mind, our goal was to identify a home with a viable and ultimately long-term solution that included both licensed practitioners and an established and secure facility to hold, house, and maintain these embryos. And so we set off on basically evaluating what other options existed within the city of Nashville. And we found a great partner that ultimately agreed to take these on and introduce them to a segregated kind of area inside their already existing um, area where they hold these particular freezers. It's important to know we had 6 freezers, and I want you to kind of visualize the freezer is not like a freezer you would put meat in or something that's connected to your refrigerator at home. These things are like oversized trash cans that are filled with liquid nitrogen, and it's critical that the liquid nitrogen never gets below a certain point. If you recall the way I opened the story, we had no employees. And so I personally am not qualified to kind of administer or add liquid nitrogen. So we found a very wonderful person from the overall fertility community who learned of the plight of this and was willing to donate their time and put their license on the record to say that these embryos were being cared for appropriately up until the point at which we were able to transition them to this identified kind of custodial party.
Very, and this is in front of a state court judge, right?
Yeah, so I also carry an interesting distinction that we started in front of a state court judge. The borrower kind of thrashed around under the controls of the receivership order. They actually filed bankruptcy halfway through. There was a contemplation of me being a Chapter 11 trustee. That also bounced the state court action to a federal court. So at one time, I was potentially a federal court receiver. So I guess in the context of, do you, I don't know what award you would win, but I guess in one case, I've been in all 3 jurisdictions as some
Mhm.
type of a fiduciary role. I will tell you that every judge we encountered here literally looked at this like it was a nuclear radioactive piece of litigation that they wanted nothing to do with. And they could not
Really?
possibly wrestle with the idea, especially the bankruptcy judge. He's like, why is this in front of me? There are no impaired creditors. But I desperately want to ensure that everything is done correctly for the sake of these patients. But you have no bearing being in my court because essentially there is no impaired creditor here. What are you doing?
And at the end of that journey, did you find yourself back in front of your original state court judge?
Just recently, the borrower originally put the entities in bankruptcy to avoid the control of the receivership order. We successfully got it back out of bankruptcy and remanded it down to the state court level. We
Okay.
also removed it from the federal court back to state court. As the pressure mounted on the borrower filed personal bankruptcy and further entangled the corporate entities. And so there was a stay on us as a receiver for a period of time, but we were allowed to continue because nobody wanted to jeopardize what was in place. So we just recently were able to overcome that stay, and we now have full control of the entities again to really conclude the receivership with a variety of different things, to include multiple thousands of patient records that are critical and important for the individuals that either have embryos that are waiting to be adopted. I'm sorry, that have embryos that are either connected to, willing and loving parents, or those that are willing to be adopted. I think it's important to say, as the population of the 1,500 embryos that I had, 500 of them were unassociated. And what does the unassociated mean? It means that the doctor used extra embryos from willing female patients that they identified, look, we've had 2 children. We don't need the balance of the embryos that we have on deposit with you. We will abandon them. Perhaps their belief was that they would be disposed of, but instead the doctor utilized them, used sperm from a sperm bank, created designer embryos, and was marketing them for sale.
So, fairly straightforward case. No, I'm just kidding. So, you've got the procedural rules, you've got a receivership order, you've got removals to bankruptcy, to federal court, back to state court. the entire time you remain responsible, perhaps even though technically you've been, I mean, someone could argue divested at different points, right? Once you're in front of one court versus another, because the procedural rules, they kind of just say, here's what this means when there's a removal. Here's what it means when there's a remand or whatever the situation is. But you're maintaining this throughout this very complicated legal procedure, which would be flummoxing for many folks, while at the same time navigating a whole host of um, parents to be and the embryos, and then another 500 to whom there is no name or known association with any individual in the world. Is that?
That's that's correct. Yeah. I mean and I think it's also important to note that again, our stakeholders were these people that were ultimately believing in the promise of what fertility could do for them. And so
Mhm.
knowing individuals that have gone through this personally, I mean, it's literally the peak of their emotional life. These
Yep.
are really hard situations, and they're at these places in their lives not because things went well, but probably because these are opportunities of last resort to create a family. And so, we understood that, we recognized the sensitivity of it, and tried to manage that. Unlike a secured creditor and perhaps a borrower that goes sideways, and you know, not to say that those things don't equally matter, but I think this is uniquely different, and we understood that and tried to manage that appropriately. But that is an additional dimension of handling these folks that are eager and desperate for answers. How do they believe in a process, and how do we usher this through to something that they can simply get back to doing what they wanted to do, which is receive their embryo, have it implanted, and potentially hope for the best in terms of building a family.
Well, and I'll ask you the question that I asked Brent earlier on, because I know I do bankruptcy. I'm obviously a proponent of receivership, very involved in that. If not receivership, what would have been the best alternative way, considering not only the legal rules and requirements and hearing notices and time it takes to get hearings and whatnot, what would have been the next best, or what would have been an alternative way to handle this situation where you have to transition essentially 1,500 live human beings or 1,500 human beings who have been put into your care into a safe space so that their families can someday actually have children? What would be the alternative process, do you think, for handling something like that?
When we surveyed the domestic marketplace to see if there was an analogous situation that had come before us, we were made aware of one particular case in a bankruptcy context that involved a fertility expert or a fertility storage facility, I believe. It wasn't an actual clinic, but it was a storage facility. I think in that context, they used a healthcare ombudsman. But I think where the benefit of this receivership came into play, different than my experience with healthcare ombudsman, is that a healthcare ombudsman is an advocate for the patients, but I don't think they're a very solid execution party. I think what we were able to provide is, I want to believe, both, where we ideally had the patient's best interest in mind, but we also created and executed a plan that was able to kind of usher this from utter chaos to that of a stable, relatively normal existence through a period of time. And so that's a long way of answering your question, but I think bankruptcy could obviously always be an option. In this particular case, the judge had very strong opinions about why it didn't work.
Okay.
But I think obviously there's a case law, or there's an example out there that bankruptcy did work for another case, but I don't happen to know the particulars of that other case, and if there was a secured creditor that's willing to fund or what have you.
Okay. Well, I'd like to move away from life and death cases a little bit, if you don't mind. I want to turn to Baker because one and somewhat more common, but not altogether common, is a receivership dealing with an automobile dealership. And I think for someone who hasn't worked with automobile dealer clients, you might think it's very standard. But in fact, and Baker can go into this in more detail, the background accounting at an automobile dealer it rivals hospital accounting in its complexity. And I know that Baker's handled a number of cases in a number of situations dealing with automobile dealerships. But I think what I'd like to ask Baker to do is give us some background on how those cases generally work and how a receivership process is a valid and useful tool, perhaps, that is better in maintaining values, I think, unless you disagree, but I think it's better at maintaining values than maybe simple foreclosures or other possible remedies. But Baker, I'll let you elaborate on that.
Thank you, Eric. As I'll back into it the way you introduced it. The accounting is in multiple levels, multiple buckets. When you think about a typical business, you're looking at top line revenues minus costs equals profits. In automobile dealerships, revenues are rarely talked about. It's mostly units of gross margin. How much gross margin did I make? So when you sell a car, you're really saying, how much margin am I going to make on selling that car? And when we talk about margin, so many people who either from the consumer side or even from the business side, when they look at a car dealership, they say things like, well, we have the car sales piece, we have the service piece, we have parts. And yes, you must run parts and services well, or you will bleed cash. And you will also, if you don't run those two well, you will lose customers because they will hate you for poor service and poor parts availability, and they will cause you grief with the OEM who takes this seriously, who's always looking at all these aspects of your business, giving you ratings, adjusting your discounts that they give you based on that. So it's not parts and service. Where do you make the money? It's really not even on sales of cars. The sales of cars are needed, and you must keep your numbers up. But where you make the money when the car is sold is on the OEM, the manufacturer rebates, and finance and insurance. And from those of you listeners who have bought cars and find yourself when you're ready to walk out the door of the car, sitting in someone's office who's talking to you about financing the car, selling you insurance, and you're thinking, what's this about? That is a huge profit center for them. And there are more profits on many models of cars on OEM rebates and finance and insurance, that little add-on piece before you walk out the door of the car. So if you're losing more money than you're making for a variety of reasons, which we can talk about, what may happen is you run out of cash, you the dealer, begin to not transmit to the OEM the funds you receive for the car. What you're supposed to do within just a few days, you keep your part of the money, but you got to pay them for the car or pay who you borrowed from. Many dealers are financing through either the OEM's finance company or a nationwide automobile finance company. They're doing floor plan financing. You've got to pay that floor plan down. If you don't, you're out of trust. And that may be the trigger that brings about the receivership discussion. And what everybody knows is if they come and pick up all the cars with their trailers, with their car trailers, it is over. And all you're looking at in the dealership is a bunch of assets that are competing with other out of business dealership assets. So a receivership, preserving this as a going concern while the receiver figures this out, gets it back to break even, maybe shops around for a buyer, is going to deliver much better results to all the secured parties. And we can talk about that in another question.
If I
But
could
a
ask, isn't
receivership
it
is gonna give you
true?
better results.
Isn't it true? I mean, the way you've described an automobile dealership, it's not a store, it's an ecosystem. And within that ecosystem, you've got a building owner. It may be the dealer directly, it may be the dealer has a separate entity, and then there's, rent back and forth. You've got parts and service, which has its own series of purchases and inventories and sales and pricing and different things like that. Then you've got what's out front, which is you've got your showroom and you've got cars and you've got salespeople trying to make commissions. And then behind the scenes on those cars that are sitting on the lot, you've got a floor plan financer who's waiting in the wings to get paid, and who, if I understand correctly, if a car sits more than, I don't know, 30 days, they start to charge curtailments, which if you ultimately do sell the car, they may apply those proceeds first to curtailment, so the payment may not fully satisfy the car, in which event you also have your purchaser who's expecting a title, a plan financer who may or may not want to release the title. And all of this is kind of operating together within this stew that to us, as we drive by, it looks like, well, there's a place if I give them some money, they give me a car. Now, in a typical receivership, right, and I've used this as the prototype earlier, it's a building with, a landlord-tenant situation or something. But you use receiverships to deal with these complicated ecosystems where the ebb and flow of cash is always shifting. How do you go about, number one, initiating that process, and number two, keeping the judge informed? Because I think judges are like most people, they may not know of the complexity of the back end office of a car dealership. What's your approach in dealing with kind of just the management of the legal process while also managing this complex financial situation?
A couple of things, and I am simplifying here, Eric. And I'll interject a couple of things to keep an eye out for. But on the keeping the judge happy thing, you don't want to have the lawyer for the floor plan lender coming into court and demanding that they be able to pick up all the vehicles. And the best way to do that is do not keep going out of trust on the vehicles. If, as best you can, given the cash resources that you've got, try to stay in trust as much as you can. Sometimes when times are bad, you go in and out of trust, and you get little notices and they say you're out of trust and you got 3 days to get back in trust. Scramble around, get back in trust as fast as you possibly can. If you can get cash to break even, try to stay in trust. Don't use going out of trust as a way to generate cash. It will drive you crazy. The second thing is when you talk about the building, and when you talk, first of all, I had a situation where we had both the floor plan lender and the mortgage holder on the building who were the car dealership was in default with. Try to have a reasonable conversation with the mortgage on the building. And I'm saying this for the benefit of all of our listeners. They came back with, we have an appraisal. And, if we get the building, we are perfectly comfortable because our appraisal says we are good as to this loan. And they kept up with that attitude, would not cooperate on cutting a deal with us and the floor plan lender. And they took the biggest haircut on that building because it was just an empty dealership, a beautiful Taj Mahal of a building, but just another empty dealership among many, many empty dealerships. The other thing, to answer your question on the inside, there are two key people in the dealership that you have got to get your arms around. One is your general manager, one is your controller. They may seem like, when you compare them to other businesses, they may seem like unimportant people, but both of them can sink you. You need them to be on your side. You need to be communicating with them. And if they aren't natural communicators, or like many, many, many car dealership people who move from one dealership to another and who get a little bit jaded with the whole world, they don't feel like telling you what they're doing. But that general manager can create bad paper. He can create situations that are going to come around and bite you. I won't get into that detail. Eric knows what I'm talking about. The controller knows all the money that comes in, all the money that goes out, and they can be your right arm person on controlling all these flows of cash into the various buckets.
Let me ask one related question, because we've talked about how a receiver, I mean, in all of these different scenarios, it's manifest that having the right receiver in place who knows this business, knows how it operates, or can figure it out, and then understanding also how the receivership process as its own standalone legal process works. And we've talked about that in your context with the automobile dealer. But one thing we haven't talked about in that context is, what about your franchisor? What about Ford or Chevrolet or GM? How do they react when a receiver is appointed? Are they consulted in advance? What if they learn about it later? Are they likely to pull the franchise? Are they under pressure from other franchisees to say, hey, we're saturated in this market, I need you to shut that one down? What's the back end politics that the franchisor is dealing with? And is a receiver, how do you navigate that when you've got this distressed situation?
They are very, very, very important. It does not mean that you communicate anything and everything to them, but you can't keep them totally in the dark. That would be very unwise and unwelcome, and it would backfire on you. But they are important for many reasons. They will do nothing for a while when you struggle financially. A lot of times the dealership owner has been complaining about the lack of support of the OEM, and many times that's well taken. If the OEM is careless with the location of other dealerships for the same brand of car, that can really hurt the dealership you're the receiver for, because it'll pull away sales, it'll pull away loyal customers who you want to depend on you for both service and parts. Those are important cash flows, and if they can go just as easily across town to another dealer, that's bad news. So the overall attitude of the OEM is important, but they don't necessarily lift a finger. They sort of stand by while you're going through this. You're communicating with them regularly, because if your ultimate solution, and you think about both the hog dealership and the embryo clinic, the fertility clinic, if your ultimate solution is to get the major assets with somebody else, you are going to need the cooperation of the OEM. They will frequently have a prospective buyer. They're not necessarily going to bring you 2 or 3 prospective buyers. They may have one prospective buyer that they're backing. You may have some interested buyers that come out of the woodwork. They will frequently be with a similar brand from another city, 1 or 2 states over. They'll come and say, we want this dealership also. You got to have the OEM on board to do that. And it's not a slam dunk. to be an automobile dealer, there are basic net worth requirements for the new owner, and there are both character and reputation requirements. Character, because they don't want criminals using it to launder money, but reputation, because if they have a crummy reputation with customers in other cities, the OEM really doesn't want that. That is a genuine issue with them. It's a real issue. When for those in the audience, when you get these, you've taken your car in for service and they say, now you're going to get a call and we'd like a really good rating from you for, with the OEM. They're not kidding. That's very important to them. So that's the OEM's role. And like I said, they're probably going to be most critical when you get it stabilized and you want to find a new owner for this.
Well, so, and you all add or correct anything I've said, but there are a few takeaways that I've got gleaned. And, my view is receivership is a good process. But let me just share with you a few takeaways that seem to be accurate amongst this group of receivers who are probably among the most experienced that I know. And that is, number one, everyone's touched on at some level the importance of the contents of your appointment order, and that you have someone, an industry professional such as your receiver, who's experienced in this, weigh in on the contents of that order before the judge signs it. Number two, alignment of the stakeholders is critical to success of a receiver. And you've got to have some level of industry knowledge or the ability to acquire it, I suppose, in order to figure out and achieve the necessary alignment. Because once you have, whether it's in the hog farm scenario, a regulator or a bank trying to shut you down, or in the car dealer scenario, your floor plan financier or your OEM going sideways on you, or in the case of the fertility clinic or any other kind of very complicated situation, you've got consumers, you've got a consumer protection regulator, you've got someone who you want to take these products on and keep them safe. You have to have alignment, because once you don't, as Jerry mentioned, when the owner of this clinic wasn't in alignment, he created all kinds of chaos, traipsing you through different courts. So the importance of alignment of the stakeholders sounds like a critical feature if you can achieve it. And I suppose if you can't, that'll be my first question. What if you don't have alignment? Is the court, is the judge your best resource to be able to continue on the path that you've determined to be necessary?
Yeah. Do you want me to start, Eric?
Please, Brian.
You are, as a highly experienced attorney, one thing. When everyone shows up in the courtroom and sings from the same hymnal, the judge is very responsive to that message. It is discord and it is disagreement that creates the biggest obstacle in the courtroom. So I can't say how I completely agree with you. It is extraordinarily important to create a unified approach to the problem. You can't always do it, but you have to try.
Okay.
Yeah, like I'd echo that comment. I think we really work really hard to make sure that stuff doesn't play out in the courtroom and that we find consensus before we get there, and or we build as much consensus as possible in terms of prioritizing who we want to find alignment with. Clearly, we want to find who's ultimately the financial obligatory party to the estate, to understand their kind of connection and the things that they're seeing as important. In this particular case, obviously the patients were the most critical, and they didn't want to spend $1. But thankfully, the state of Tennessee came forward and said, look, on behalf of our patient population, who's ultimately a victim here, we will do the right thing, step in and take some degree of, they took all the financial burden of it. And so that was a delicate dance with those folks. The patients were truly our stakeholders, but the partnership with the state of Tennessee is really what allowed our ability to function and find a successful conclusion here.
Okay.
Two,
So,
two
I'm sorry,
comments from
Baker.
me, if you want them, Eric. One is the judge, it's not just a fact finder and a decision maker in a receivership. They take a personal interest in the company as much as each of us gets involved and invested and enthusiastic and emotional about being successful with these companies. So is the judge. He feels like it's his company, and if it's going to be a big failure, he's going to feel like he's got egg on his face. That's one thing, and that's the way to envision and treat the judge. When other parties are having a knockdown, drag out fight about every single issue that comes up, I've heard judges say over and over again, these knockdown, drag out fights, if we're always going to be in conflict, this case will not be successful. It's going to be tough enough to get through with all the unusual things we talked about. But if you add fighting one another at every turn on this, it will not be successful. And the judge knows that.
So in terms of takeaways, mentioned contents of the order, alignment of the stakeholders. And I think everyone would agree, robust communications with the court so that the judge isn't blindsided. When something isn't going right, you're better off telling the judge before it becomes a problem. You don't want him to find out after the trash can fires become a brush fire. But each of you also touched on this, which is the importance of the combination of industry expertise and receivership expertise. And having those two features in a single person can be hard to find. I know plenty of people who do receivership. I don't know that all of them could. I don't know how many of them could handle a hog farm or a car dealership or a fertility clinic, but having the ability to do that plus the understanding of how receivership works, I think would be the next takeaway. And then finally, understanding the background kind of business model, the financial business model that you're facing, I think is critical. And it's something that even, your lawyers won't really, they can speak the language, but don't always understand it exactly. And I think each of you has touched on that a little bit. Are there other items that you all would add in terms of you're going to come into a case, you're going to use a receivership process in this instance to deal with something that's thorny, something that's unusual, something that requires specific expertise? What other kind of red flag or what kind of other preparation would you encourage people to undertake as they kind of approach a situation that might be, in their view, novel for a receivership administration?
Hire an expert, hire a manager. Even in this hog farm case that I ran, Eric, where I was the receiver, even though I was fully capable of running it, the farmer had threatened to kill me if he caught me on the farm. And I simply had to hire a swine manager to go in and into the hog buildings because I wasn't going to walk in there with a man who the bank warned me might actually proceed to do so.
And not to share my own war stories, but I've had instances where I've had to hire retired special forces personnel to accompany me to properties fully armed, right? That happens too.
Yeah, the thing that I would add, Eric, is our fundamental philosophy in terms of when we get involved in things is trying to be good listeners on the front end to try to understand the story. And one of the fundamental principles about how we go about things is the closer you are to the product or the service, the less broken it is. And we really we don't talk to the executive team first. We really try to get close to the product or the service, and we listen to what it is that they think went wrong. And then by the time you work your way up, you have a much more candid and unvarnished kind of opinion of where the issues are. If you start at the executive ranks, they're going to give you every excuse and tell you why everything they tried to do didn't work or they're the smartest people in the room. If you go to the people down below, they'll be the first people to point out, hey, they made this mistake, they didn't do this right, whatever. And so by the time you get to the executive team, you relatively have a good understanding of the landscape and how and why things may have fallen apart.
Yeah.
One thing
Good
you
advice.
covered, Eric, is the order. I just add one little nuance on the order. Many times when we've been asked to be receiver, there's been opposing lawyers who are thinking, well, we'll just throw a receiver at this. And the two sides are not agreed on anything, but maybe they can agree on the receiver. And what I find is, unless we are diligent that what's in our engagement letter makes its way into the order, it is not, they don't care. They don't care whether we get paid. They don't care whether we have the authority to do what needs to be done. They don't care about any of that. And so if you who are contemplating being receivers actually have to pay for your own lawyer to make sure all that happens, it's worth the money.
Good advice. Well, we are at the top of the hour, which I think is signals our conclusion. I want to thank you all once again for, I think, a great discussion. I really appreciate it, and I think did a fantastic job of demonstrating how receiverships can be used in novel situations to rectify very thorny problems. And so I think that's a great benefit to, I know it is to me, I'm sure to the listeners, and I just want to thank you all very, very much.